You're watching Capital Connection from the Illinois State Capitol.
Welcome back. Now, part of talking about the end of a spring session is talking about the things that did not get done. One of them was a big push for a statewide public defender's office. And this push was started by Senate President Don Harmon, but was actually opposed by public defenders across the state. And this, in the past few weeks, we really saw public defenders make their own push for this. Joining us now is one of those public defenders. It's Elizabeth Pollock, the Champaign County public defender. Thank you so much for joining us.
Thank you for having me.
So I guess I just want to start here. When we talk about the need for a statewide public defender's office and what that would bring and give to the offices across the state, what are the biggest advantages of this?
So as it stands right now, the public defense system in Illinois is county-based, which means that certain counties do provide for a full-time public defender's office like Champaign County does. Other counties don't have a full-time public defender, and they rely upon private attorneys, either who have a contract to accept those cases or who sometimes just pop into cases on an as-needed basis. And really what you end up seeing is that the expending of resources varies significantly county by county. So some of the smaller counties simply don't have the budgets to fully fund a public defender or to adequately fund a public defender's office if they do have it. So the hope for a statewide public defender office is if we, attribute resources to this group. If we say, look, we need help in this county, or they need an investigator for this case in this county, then to be able to supplement the resources that a county public defender's office has, or in most cases does not have, could be extremely beneficial to remedying the disparity that exists between the counties. Because right now, what money you have for your budget depends solely upon your locality. And we know that sometimes in the state, we've got counties that have bigger budgets, we have counties that have smaller budgets. And regardless, the investment in public defense services is less than it should be across the board. So the hope is that a state public defender office would be able to supplement those county budgets and to provide services in the counties where perhaps there isn't even a full-time public defender.
I mentioned that the Senate President's first attempt at trying to do this was actually opposed by public defenders. That had to do with the issue of autonomy for this kind of office. His proposal would have put it under the state Supreme Court rather than its own independent entity. And I wonder why that part is so crucial for this conversation. Is it just a perception component, or is there an actual procedural component to this, something that changes the way that office would really function?
Well, pretty much every national entity that has studied the issue of public defender independence has come down on the need for public defenders to be independent of either political or judicial influence. And, I'm certain that there are people who have never had an issue with their judges. I'm one of them. I have never felt as though I was pressured or I couldn't do what I wanted to do because I was nervous about what the effects of that would be. But that's not true for everybody across the state. And really what it comes down to is an appearance of impropriety. If you imagine that you're a client of a public defender and you know that if the public defender were to irritate a judge or do something that the judge didn't like, that the judge has the ability to terminate that person or to cut a budget or to do something that would otherwise negatively impact the office, you would be nervous that your attorney wasn't advocating as fully as they could because they were worried about what would happen to them. And so the principle of independence removes that threat. It removes that appearance of impropriety. And what it does is it ensures people that the public defender can fight as zealously as they need to. They can make any requests they need to. They can argue what they need to, and that they can do that without any fear of interference in the future. So that's really where the principle of independence comes from. The American Bar Association has recommended it, as well as a study of the federal judiciary, the Cardone report that came out a few years ago. They really just want to make sure that public defenders are wholly insulated from even the appearance that their performance might be impacted by a fear of what would happen to them if they did so.
When we talk about resources for county offices, the way we see public defenders' offices right now work across, for the ones that have them at least, it seems very, very solid, very separate, I guess. There's not, and that this push would obviously cure that. What does a overarching organization really do for just the advocacy side of this when we're talking about the resources that these kinds of offices need? What does an overarching organization really do for that kind of push?
Well, I think what it will do is it will ensure that the disparity that we currently see between counties is the gaps are filled. Because right now we have some counties like Champaign, which is large enough to have its own public defender office. We also have a lot of counties that don't, that only have independent contractors or maybe have somebody who kind of steps in from time to time. And those resources are very disparate. So some counties have more resources than others. And what a state commission would do in a state office, it would be able to supplement those budgets where the counties themselves are not able to afford the services that the public defender really needs. And when you talk about counties, I mean, counties have limited amounts of funding. Counties are they have a lot of responsibilities. They have to take care of all the different departments, and so public defenders are just one piece of that budget. And if there's no money left, then there's no money left. We can't support hiring additional staff. We can't hire investigators or social workers. We can't pay for expert witnesses if we need them in certain circumstances. So the hope is that by consolidating a budget in the state office, that would help filter down to the areas where it's most needed, especially in the counties that are smaller, that don't have the resources of the larger counties. It would make sure that that disparity of representation is eliminated.
When we're talking about the job of a public defender and the representation that people have a constitutional right to in the courtroom, it's that the level of that representation seems to not really have a clearly defined level to it, like at least a standard to it. And what I mean by that is that there are, a dozen or so public defenders, at least in Sangamon County. I think the latest number that I counted was just around a dozen public defenders and assistant public defenders in the office. And there's hundreds of cases that can go through that county. I wonder, when we're talking about the constitutional right compared to what it actually takes to adequately represent somebody in the courtroom, does there need to be clearly defined standards and if so, does a statewide organization like this actually help in that regard too?
Well, there does need to be a standard. The last time anybody really looked at the workload of public defenders was back in the 1970s. And based on the numbers that they came out with during that time, they said, for example, a felony attorney could handle 150 cases a year. When you break it down in terms of the number of hours that you can spend on each case, looking at our current caseloads, we're spending, we would have to spend no more than 5 to 10 hours on a particular type of case. And that's just not going to be sufficient. It's just not. We need to dedicate more time and resources to each of our clients in order to be able to adequately represent them. My hope is that with data, which we don't have a really good statewide way to collect data on numbers of cases, numbers of hours spent on cases. Excuse me. The hope would be that a statewide office would be able to help us generate that data and then advocate for an appropriate workload.
Got it. So I guess, and talking about that workload, I guess, for this conversation has started recently because of that study that was commissioned by the Illinois Supreme Court, and kind of in the wake of the Safety Act, I guess. It's caused a re-examination of that, as you've already addressed. These problems stretch well beyond just the beginning of when the Safety Act was implemented in this. But I wonder, as we take a look and we're seeing such a major change to the way that this entire system plays out in the courtroom, how crucial is it that the full scope of this gets taken into account and not just what needs to happen to accommodate the changes in the Safety Act alone?
Well, the Safety Act certainly did generate a lot of change, and it definitely increased our workload, especially on the front end of things when we're initially assigned to a case. So I'm glad that the attention has come. The fact is that we've needed a lot more help for a really long time. So however the attention came, I'm glad that it's here. It's generated this conversation, which I think is incredibly beneficial. There have been reports, I think back in 2021, the Sixth Amendment Center did a report that was critical of the provision of public defender services in our state. And so it's starting to come to light now, and the Safety Act has only further shined the light on how under-resourced we really are, and how inadequate our resources have been over the years. So my hope is that now that this issue is out there in the forefront, people are paying attention to it. People are beginning to recognize that, we have a baseline level of representation that we need to provide. It is in the Constitution that we have to be able to do this. And so now that we are actually trying to study the issue, my hope is that a statewide commission would be helpful with that. Office of a State Public Defender would be able to synthesize that data. They'd be able to talk to the individual county public defenders and figure out what the needs are and how we can better serve our clients, because our clients they're our community. These are our neighbors, our family members, our friends. And we really want to be sure that just because something has happened in their life and they've become charged with a criminal offense, that doesn't negate their humanity, and it doesn't negate their right to be able to have an attorney who is skilled, who is an excellent advocate, who has the resources to fully investigate their case, who has the ability to really delve into what's happening in their life to try to figure out the reasons why and to develop a defense for them. So if we get this Office of Statewide Public Defender eventually, my hope is that those gaps in representation, which are not a result of the attorney's performance or ability, but more this result of under-resourcing, that those gaps are going to be able to be filled, and we're going to finally be able to meet our constitutional mandate.
All right. Well, Champaign County Public Defender Elizabeth Pollack, thank you so much for joining us.
Thank you.
That will do it for us on this week's episode of Capital Connection. Thank you so much for joining us as well. We hope to see you again next week, where we'll continue to break down all the happenings of the final days of the spring legislative session. For Capital Connection, I'm Cole Henke.